Hey guys, I was just as surprised to learn today, as you probably were, that Richard Allen's lawyers had asked to withdraw from the case and the judge was granting that. That's a surprise. I didn't see that coming. Not really sure what's going on with this. I was kind of not buying the whole idea that it was all because of these possible sanctions, because if you withdraw out of the case, you've kind of given that issue up, right? And these guys seem very determined to defend Richard Allen. I don't agree with everything they say, but they've been very active on the case. So for them to say, hey, we just want to drop out of this case, why would they do that? I don't know. Yeah, the judge might sanction you in some way, but even if you drop out of the case, the judge could still do that. It's not like you're just home free. You can't even leave the case unless the judge says, okay, you can leave it, although apparently she's doing that. Now, if she was thinking about removing them from the case and they decided to go ahead and do it, and that's all she wanted to do to them, then that could explain this, but that is still very bizarre because his attorneys took the position you shouldn't throw us off the case, that we've got to finish this case. And it is coming up in January, and now it's going to get delayed. So I find it all very bizarre. But more bizarre, apparently one of the attorneys had an attorney come into the case to represent him for the limited purpose of arguing about these possible sanctions. And they filed a memo, and that's what I'm going to look at it with you here real quick. And it does this being filed, and you'll see the arguments. You'll be like, okay, you went to all the trouble to file this, and then you just dropped out of the case. It does seem contradictory because I can agree with some of what the defense is saying here. Let's take a look. All right. Memo regarding possible disqualification or sanctions. Any concerns or issues regarding representation should be focused on the Sixth Amendment right of the accused. Continuity of counsel is critical for adequate representation. That's a logical argument. Okay. Allen had developed a strong and trusting bond with Mr. Baldwin. It's one of the two attorneys. So, okay, but he quits today. I'm not throwing shade on him. I just don't know what's going on. Disqualification of either of his court-appointed attorneys would greatly prejudice his right to counsel in a timely trial. Yeah, and maybe the judge was hinting to them somehow, although none of this is on the record, that she wanted to get him out. And the other one's like, well, if he goes, I go. I just don't know. But anyway, he's making the point here. Don't take us away or me away. Allen, trust me. We're coming up on trial. If you throw either one of us off, you're screwing up the case. And here they say the Sixth Amendment guarantees in all criminal prosecutions the accused shall have the assistance of counsel of choice. The authority to remove appointed counsel is limited and has resulted in reversals in other jurisdictions. And again, this is my point. If you voluntarily withdraw out of the case, you've kind of given up the potential appeal for being thrown off wrongfully of the case. Maybe. So it's a little strange. Like if you thought the judge was going to wrongfully throw you off the case, why wouldn't you put her to that test? See if she'd actually do it. I don't know. The trial court may not remove a defendant's counsel merely over disagreement regarding conduct of defense counsel. They're saying here, and this is, see what state that was. Looks like Michigan and Minnesota. A court, and again in Michigan, a court may remove a defendant's attorney on the basis of gross incompetence, physical incapacity, or bad conduct. In the present case, the judge did not remove him for those things. He was removed for conduct allegedly committed in other cases or outside the courtroom. So that would clearly be wrong. Disqualification of counsel is an extreme remedy for any alleged or perceived violation of a court's order. And that's true too, right? Because Richard Allen's in prison. He didn't do it, right? So if he has competent counsel, losing them is to some degree punishing him as much or more than the lawyer, especially if it's all that happens to the lawyer. So I get what they're saying here. Most, if not all, cases concerning disqualification of counsel involve conflicts of interest. Right. That would be the typical case, or some major disagreement with your client that you can't go forward with them. There's no case allowing disqualification when an individual not part of the attorney's office or staff surreptitiously purloins information from the attorney and disseminates it without permission or the attorney's knowledge. And for these leaked pictures, that's also what I had thought, that like somebody took these pictures and it wasn't the attorney leaking it or something like that. So how directly could you hold the attorney responsible for that? Now, unfortunately for the attorney, I think there's some facts in here that show that the court could say, I've warned you and you should have been more careful. So we'll see. Furthermore, any sanction first requires proof of knowing, willful, or intentional conduct, as do the rules of professional conduct. Here, the attorney's trust and office were violated without his knowledge. The rules saying you shouldn't disclose things are for the attorney, not by someone who purloined information without the attorney's knowledge. A lawyer must act competently to safeguard information relating to the representation of a client against inadvertent or unauthorized disclosure. And maybe that didn't happen here due to the trust, and they're saying. Attorney Baldwin did nothing wrong. He was snookered and abused. Okay, some trial lawyering type of language there. And here's the Indiana appellate case, which reversed the conviction because the trial court erroneously disqualified counsel when the accused had waived any perceived conflict. And they cite all that. This court is of the general view that the trial court is limited in its authority to remove a criminal defendant's court-appointed counsel. Remember, all these arguments occurring before the hearing was canceled today to convince the judge, like, do not throw me off of this case, and then they withdraw from the case. The issue before the court is a horrible tragedy created by persons not related to the defense of Mr. Allen. There were 3 disseminators, one who committed suicide after the law enforcement investigation began. So that's awful. It should be considered a law enforcement investigation. There's the old saying early in law school that if someone is going to jail at the end of the case, make sure it is your client and not you. It should be considered that nothing has been disclosed that wouldn't be disclosed at trial or hearings. Yeah, I think that's underselling it a little bit. I think, from what I've heard. It should also be considered there have been volumes of information disseminated by law enforcement and or others. So a little bit of whataboutism here, that wouldn't really convince anybody. That works on social media better than it does in a courtroom to go, but what about him? Officer, why didn't you pull over all the other people who were speeding? No, you need to answer for your own conduct, whatever that is. Mr. Baldwin trusted a friend to respect his office space. He was betrayed. Since that transgression, Mr. Baldwin has kept all his Delphi-related materials locked in a room or locked fireproof file cabinet. And you kind of wonder, maybe for those type of sensitive things, maybe you should have been doing that already, especially if you had a leak or some kind of inadvertent disclosure before. It's easy to say that, small law practice. You do want to trust people. I'm trying to think about, big firms we had, for sensitive things, you sometimes had a whole floor. You had to have an ID to get on it. Case files locked in the cabinet when somebody's not really working on it. But small firm can be a little bit different. I don't know. Obviously he should have kept it locked up and he shouldn't have trusted anybody, but he did. And the question is, what was the price to be paid for that? Taking Allen's lawyer away from him, I agree with the defense, would be a very high price to pay. And in fact, they suggest another sanction here if the judge does want to punish him. But let's finish this. All right, he was transgressed against. And since then, he's kept everything in a locked room or fireproof file cabinet. Furthermore, defense counsel has put together a plan for curative action in which no items will be left unattended for even a second in any unlocked room. When any document or items from the case are needed for preparing the case, the person using the document or item will either lock the door behind them when they leave, even going out for lunch or the bathroom, or return those documents or items to the room dedicated to the Delphi case and lock the door. Vast amount of trial preparation materials, and it would be a setback to the defense to have to relocate them. And it says, as Mr. Rozzi indicated. So I think there have been, some discussions going on about this. Not everything is public, or almost nothing is public in this case. When they finally made a hearing public, they didn't have the hearing. Under these circumstances, Mr. Baldwin has taken sufficient curative action. Should the court believe there should be some sanction, the court could order him to do 24 hours of representation without compensation. So they're even suggesting here, listen, judge, I didn't do this on purpose. I trusted somebody else, and they took advantage of that. We're doing things to make sure this never happens again. It's terrible. However, you'd be punishing the defendant, and perhaps more than you should. You'd be risking a conviction being overturned on appeal, judge. You don't want that. If you feel like you need to whack me with something, whack me with 24 hours of representation without any money. Now, I don't know if they discussed this with the judge and the judge, like, it's not going to happen. They're going to do something worse than that. Even if all that is true, why would you withdraw out of the case and not get it onto the record? Again, I'm not accusing them of doing something wrong in that regard. I'm just saying I don't understand it. I don't really know what has happened here in this case, because you can see from this filing, they were prepared to fight over it and tell the judge, if you try and take me off of this case, it's too much. You could put the whole case at risk. If you need to hit me with some kind of sanction or something, you can do that. You can make me work for free. I mean, a lot of times, usually there's some monetary thing or something like that. So I don't know what has happened on all this, but I thought it would be interesting to go over what was filed by or on behalf of one of the defense attorneys, I think just before they actually got out of the case. So they filed this. There was some kind of discussion with the judge, and then they withdrew from the case with the judge's permission. And now you wait until the end of October, and he's going to get a new lawyer or lawyers, and we'll see what happens then. This is just very bizarre. So we'll keep watching this case. See you guys at the weekly docket. I hope. Thanks. Bye.